Hello everyone, I'm Barrister Garn from Siam Center Law Group. Today, I want to explain one of the most common questions I receive in family law cases. If a couple lives together like husband and wife but never registers their marriage, can they file a case to divide assets? The answer is yes, you can, but it is much more difficult than for legally married couples because Thai law clearly separates these two statuses, and the rights and burden of proof are completely different. For couples who are legally married with an official marriage registration, the law presumes that any asset acquired during the marriage is marital property and must be divided equally. It doesn't matter who earned the money, who paid for the asset, or even if the couple has been living separately for years. For example, if the husband buys a house and the wife contributes nothing, it is still marital property and must be divided. Even if the husband wins the lottery and receives a large sum of money, that money must also be shared. In these cases, the person filing the claim only needs to prove that the asset was acquired during the marriage, while the person who does not want to divide the property must prove that the asset is personal property, an inheritance, or an individual gift. However, when a couple lives together without registering their marriage, the law does not recognize them as legal spouses. This means no automatic rights over each other's assets. The general rule is simple. The asset belongs to whoever's name is on the title. If the house, car, or money is under the other person's name, you do not have any immediate right, unless you can prove one of the following: co-ownership or life partnership. Co-ownership applies when both parties contributed financially, such as jointly paying for a house, running a business together, investing together, or building an asset together. In that case, the property is considered jointly owned and can be divided. The second concept, life partnership, is even more difficult to prove. This applies when you did not contribute financially, but you fully supported your partner as a life companion, taking care of the home, raising children, managing the household, allowing your partner to work and generate income. In such cases, the court may consider that you invested your life in helping the other person accumulate assets, so you may be entitled to a share, but you must prove clearly that the relationship was a true life partnership, not just a casual or short-term romantic relationship. Finally, regardless of whether you are legally married or not, certain types of property do not need to be divided, such as inheritances, personal gifts, and personal property as defined by law. In summary, if you are legally married, asset division is straightforward, but if you are not, you still have rights. You just need to prove to the court that you genuinely qualify under the law, and that requires stronger evidence and a higher burden of proof.